Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Lancey. On behalf of Judges Stafford and Golden, I'd like to welcome you to court today. You'll be live streamed across the internet, and we don't anticipate any problems, but if they do, we'll work them out. Ms. Lancey, would you call the case, please?
Robert C. Pelt et al. Versus Richard E. Benjamin et al.
Okay. The appellant ready?
Yes, sir.
All right, you may begin.
Your Honor, my name's Sean McBride, member of the Wilson County Bar, and I represent the Benjamins in this matter, who are the appellants. This case is a case of the sale of a home, and it revolves around the statute of frauds. In this case, the standard of review for this court is de novo with a presumption of correctness. We believe that based on the facts of this case and the statute of frauds, that there is no contract for the sale of this real property. A little bit of the facts is that my clients listed their home for sale, and on December the 20th, the Pelts came to the house, reviewed the house. On December the 21st, they submitted a purchase and sale agreement with other documents to the Benjamins to buy their house. That purchase and sale agreement was supposed to expire on December the 22nd at 5 p.m. On the evening of the 21st, the parties negotiated the terms of the sale. And the next day on December the 22nd, my client, Ben Benjamin, prepared a counteroffer, sent it to the buyer's agent, and it was also set to expire on December the 22nd at 5 o'clock. Come 5 o'clock that day, there was no response. There was no signed counteroffer. There wasn't anything. The parties probably went about 5 days until December the 27th, when after contact between the agents and Mr. Benjamin, the Pelts came to the house a second time. This time they came with a contractor to look at the house. While the Pelts were at the house, the Benjamins were there too. Mr. Benjamin and Mr. Pelt had a short discussion, at which time Mr. Pelt said that he would get him a response on whether they'd buy the house the next day after they'd slept on it. After the parties parted and the Pelts went to look at another home, the Pelts agent sent a text to Ben Benjamin and telling him he appreciated the opportunity to look at it the second time, that the contractor was working up his numbers, and that the Pelts were basically going out of town for the week, and they would get back with them at the end of the next week. That was December the 27th. On December the 28th, there was no response from Mr. Pelt after having slept on it overnight. And then on December the 29th, the buyer's agent called my client and discussed the sale. And as the court found, that at that time, the buyer's agent told Mr. Benjamin that her clients were willing to buy the property and accept the counteroffer. Now, again, reminding the court that the counteroffer had expired about 6 days before by its own terms. And I think that's critical because this is a statute of frauds case. There is a dispute as to the content of the phone call. The agent says Mr. Benjamin agreed to accept that and agreed that he could extend it off into January the 4th because the Pelts were going to be out of town, and they needed, as a new negotiated term, that they had to get a pre-approval letter. My client disputes that. He says that he told the agent, you're aware that the counteroffer had expired and you need to do something in writing to either revive it or send me a counteroffer, a new offer of something of that nature. Now, the court found in this regard that the buyers and the sellers in that phone call, now, my client's not having direct communication with the buyers, we're going through the buyer's agent. But the trial court found that at that phone call, at that time, my clients agreed to verbally changed the expiration date of the expired counteroffer to January the 4th in order to allow them an opportunity to get a pre-approval letter, which was a new term, was not provided in the counteroffer or the purchase and sale agreement. So it was a new term. After that phone call, my client sent a text message to the agent saying he could not talk with his wife, who is Vicki Benjamin, also a part of this case, and would have to get with her the next day. The next day, they did have a phone call, again discussing the terms of a potential sale, all verbally. After the phone call ended, my client sent a text message to the buyer's agent in which he said, "We have agreed to the verbal and the addendum, but we'll continue to show this house until we receive a written agreement and a pre-approval letter and the addendum." Now, the response to that from the agents by text message was, they're great people. The Pelts are committed to buying the house. When they get back in town, we'll get the signed paperwork to you. And that's the last communication that any party or the buyer's agent and my clients had until January the 4th in the evening at about 7:13. At 7:13, the buyer's agent sent an email to my client, which contained a copy of the expired counteroffer, which had been signed only by Mr. Pelt. He had signed it electronically, and there was a copy of the pre-approval letter. There was no addendum. And in this transaction of the verbal and the addendum, we really don't know what the terms of that addendum are, but there was no addendum attached. The next morning, my client picks up the email or sees the email at about 6:30 and immediately tells the buyer's agent that they sold the house. We hadn't heard from you. And then they went back and forth. I think it's pointed at one of the text messages, or excuse me, the emails from the buyer's agent was that as we discussed, she says, as we discussed, why didn't you let me bring their highest and best offer? Now, the trial court found that the counteroffer had expired on December the 22nd at 5 o'clock. But he also went on to find that on December the 29th, that my client, along with the agent for the buyers, had agreed verbally to extend that. And based on the law in the state of Tennessee in regards to the statute of frauds, I think in order to substantiate the law, these facts with this law, the law in the state of Tennessee regarding the statute of frauds is going to have to change. I cited in my brief in Shedd and Patterson that an oral agreement to revive a terminated contract, which terminated by its own terms, squarely falls in the statute of frauds and is unenforceable unless it's in writing. In Shedd, the court also said that an oral contract to sell a real property is not made binding by another agreed oral agreement to sell property. As courts know, the state of Tennessee follows a strict construction of the statute of frauds, and Section 4 specifically states sale of land fits within the statute of frauds. In this case, there was no communication between December the 22nd and when they asked for permission on, say, December the 26th to come look at the property with a contractor. We're still, at that point, we're simply negotiating the sale of a house. There is no contract. The only thing that the court found on December the 29th phone call was that my client orally agreed to extend the deadline. Well, if the court does change the law and statute of frauds in the state of Tennessee and does find that there was an oral agreement to extend and revive and then extend the termination date for the statute of frauds, then the whole contract comes. And if the whole contract comes, then the revived counteroffer extends to January the 4th. But it's also critical to note that if we're bringing those terms forward, we're also bringing the deadline for the termination of the time. And the prior activities of the parties showing a purchase agreement that expired at 5 o'clock, counteroffer expired at 5 o'clock. If the court determines to change the law in the state of Tennessee, then we go to January the 4th at 5 o'clock. There was no offer made. There was
Let me ask you a question, Mr.
Yes,
McBride. The court found that the statute of frauds had been waived
yes,
by, I guess, the behavior or discussions of the party. What did the court rely on in making that determination?
Your Honor, I think it was the only thing I could find was the communication on December the 29th, because the court said that in that phone call on the 29th, that the sellers and the buyers verbally agreed to change the expiration date. Now, if the court does look at
Well, the court didn't cite any authority or rely upon any case law or anything like that. Is that what you're telling me?
yes, sir.
Okay.
Yes, sir.
All right.
And I think the court simply took that there's continued negotiations, and the phone call was a continued negotiation, and therefore they agreed to extend the deadline based on their actions. But if that's the case, which I don't think is supported by the case law or really the facts, then the offer is terminated at 5 o'clock on January the 4th. We're going to change the law.
Thank you very much, Mr. McBride.
Yes, sir.
Ms. Connell, you may begin.
Thank you, Your Honor, and may it please the court. My name is Carolisa Connell, and I represent Pelts in this matter. This court should affirm the trial court's ruling that the Benjamins breached a valid and enforceable contract with Pelts for two reasons. The first reason is that there was, in fact, a valid contract between the parties. The second is that the statute of frauds is not a valid defense to this particular contract. As a preliminary matter, this is a breach of contract case, but valid and enforceable contract, that particular provision is the only element that is at issue. With respect to the validity of the contract, there really is no dispute that the Benjamins executed the counteroffer on December the 22nd, 2018. The Pelts also executed the same counteroffer on January 4th, 2019, and forwarded the executed counteroffer to the Benjamins at 7:13 p.m.
Excuse me, Ms. Connell. As I understand the purchase agreement, there was a counteroffer, and this original agreement was scheduled to expire on December 22nd at 5 o'clock, and there was never any execution by your client of the counteroffer prior to that time. So you've said that the contract didn't expire. How is that the case?
Of course, Your Honor. So the real dispute here is it's with respect to whether or not there was an expiration of the counteroffer. The Pelts have not asserted necessarily that the counteroffer did not expire originally on December the 22nd. They had not accepted the offer at that time. However,
Did it expire by its terms?
Yes, Your Honor. However, the Benjamins' actions and their course of conduct indicated a manifestation to continue to hold the offer open. More specifically, Mr. Benjamin's conduct on or around December the 29th. Mr. McBride discussed a brief.
Let me follow up on that. So you've got a contract that expires by its own terms, correct?
Correct.
There's no question that the original contract expired. That's what the trial court found, correct?
Correct.
So you don't have a contract anymore. But what I understand you saying is this contract was revived by the actions of the parties.
Correct.
Is that legally permissible when the statute of frauds requires some writing?
Yes, Your Honor. And the statute for two reasons. First, the Pelts assert that the statute of fraud should not apply in this case at all because the Benjamins waived and or are equitably stopped from asserting the statute of frauds as a valid defense.
Do you have any case law to support the fact that you can waive the statute of frauds in a real estate contract?
Yes, Your Honor. There are some cases cited in our brief, but there are that as a preliminary matter, the intent of the statute of frauds is to prevent fraudulent contracts. The Tennessee Supreme Court in Yates versus Skaggs expressly stated that while generally the statute of frauds is strictly adhered to, it should not be applied in a manner, or it should be applied in a manner to carry out rather than defeat its purpose. This court has also stated that the statute of frauds should not be used to avoid contracts or to grant a privilege to a person to refuse to perform what he has agreed to do.
Let me ask you another question. Something that's sort of been bothering me. If you have there's no dispute about the fact that the contract expired by its own terms on December 22nd at 5 p.m. How can you waive something on a contract that no longer exists? How can there be a waiver of a modification or requirement that the statute of frauds doesn't apply when you don't even have a contract anymore at that point? Don't you kind of have to start over again? In other words, whatever you have is going to be a new contract, isn't it? Doesn't that have to be in writing?
No, Your Honor, not in this particular case. In this case, there is testimony in the record that Mr. Benjamin expressly told my client's real estate agent that they would extend the offer, the original counteroffer, until January the 4th, that they did not need to submit a second written offer, and that they only needed to execute the counteroffer that had previously been done.
What do you think Mr. Benjamin meant when he said that he didn't have a signed offer and he was going to continue to show the property? What do you think he meant by that?
Your Honor, just as in any real estate contract, if there's a pending offer and they accept another offer, they have the right to revoke the previous offer that was standing. In this case, the Pelts are not asserting that if Mr. Benjamin and Miss Benjamin had signed a contract with the Owens prior to the Pelt's execution of the contract and the creation of that contract, that they couldn't have revoked the offer. It's not an option contract. However, they did not do so. The contract with the Owens, which is the other contract at issue here, was not executed until 8 p.m. on the night of January the 4th. Additionally, the facts in the record support Ms. Freeman, who is the buyer's real estate agent, her version of the events that occurred on December the 29th, and does not preponderate against the court's finding on that matter. Ms. Freeman testified that Mr. Benjamin expressly stated that there was no need for him to submit a new written offer or to do anything other than to execute the counteroffer by January the 4th. Mr. Benjamin contradicted that testimony, and the court adopted the version of facts as was stated by Ms. Freeman, and that should be given considerable deference. Additionally, the other facts in the record also support the idea that Mr. Benjamin did intend for that to occur. Mr. Benjamin and Ms. Freeman exchanged multiple text messages in which Mr. Benjamin did state that they would get the signed agreement and the pre-approval. He also responded to Ms. Freeman's text regarding her statement that her clients were out of town, but they would get all of the executed documents to Mr. Benjamin by Friday, which would have been January the 4th, to which Mr. Benjamin responded, "K, thanks," or "K, great, thanks." There's also testimony from interested parties that supports Ms. Freeman's version of the events. Ms. Benjamin herself testified that Mr. Benjamin told her that the Pelts were attempting to revive the counteroffer when they got back from their trip. And Mr. Owen, who stands to benefit if the Pelts are unsuccessful in this litigation, actually testified that Mr. Benjamin told him that there was a pending offer on the house in that first week of January. While Mr. Owen could not expressly state whether that was the Pelt's offer, the Benjamins testified that there were only two offers ever received on the house, the one from Mr. Owen and the one from the Pelts. Accordingly, if there was any pending offer at the time in that first week of January, then it had to have been the Pelts. Mr. Benjamin's actions in this case clearly indicate that he intended to extend the counteroffer until January the 4th, and the Pelts executed the counteroffer by that date, prior to the Benjamins executing a contract with any other party. Additionally, the Pelts assert that the statute of frauds was satisfied through multiple writings. The first writing is the counteroffer, which contains all of the terms and conditions, including the purchase price, closing date, other incidental issues. The second writing that satisfies the statute of frauds is the text messages between Mr. Benjamin and Ms. Freeman, which clearly indicate that Mr. Benjamin intended to extend or create a new expiration date of January the 4th, 2019. The only other issue that I would like to briefly address is the applicability of Tennessee Code Annotated 6621-108. As a preliminary matter, it only applies if a party prevails in an action establishing the validity of a lien. The Pelts assert that the Benjamins should not prevail in this action at all. But even if they were to prevail on appeal, this is not an action to establish the validity of a lien. While the Benjamins did bring a slander of title claim in the trial court, that claim was not appealed. And this is simply a breach of contract case at this point, and any prevailing that the Benjamins have at this point is not on that validity of a lien. Additionally, the Tennessee 6621-108 was repealed prior to any assertion of that cause of action against the Pelts, and therefore is also not applicable. For those reasons, this court should affirm the decision of the trial court and refuse to allow Mr. Benjamin's express actions and clear conduct indicating that there was no requirement for there to be a new written offer and that the execution of the counteroffer was an acceptable form of acceptance, and hold that the Benjamins did in fact breach the Pelt contract.
Thank you, Ms. Connell. I don't see any other questions. So we'll go back to Mr. McBride for his rebuttal.
Yes, sir. Your Honor, in regards to, I guess, the course of conduct of the parties and the question of estoppel, course of conduct, we're dealing with two real estate agents. Ben Benjamin's a real estate agent, and we were dealing with the buyer's real estate agent. Their course of conduct was in writing. The course of conduct was initially started by the Pelts when they sent a purchase and sale agreement with other associated documents. And then in the evening of that same day, they negotiated the sale. And the next morning, my client gets up and sends a counteroffer. The course of conduct is something detailed in writing. We're not dealing with two people that don't know anything about the statute of frauds or contracts for the sale of real estate. Their course of conduct is clearly putting something in writing before to consider to negotiate. But the bigger issue is that the contracts themselves terminated. So it's a brand new, I'm going to say, negotiations. And then at that point, the issue is, can we, as I've cited in your brief, one, orally is found by the court, the trial court, which has no support in the case law, that he orally agreed, one, has to revive the counteroffer because it expired. The other is that we had to modify the terms of that expired counteroffer to extend it to January the 4th. If that's the case, and if the Benjamins were working on the assumption that we had an oral agreement to sell the property, worst case scenario, if this court does change these circumstances or change this case law, then the contract itself, based upon the arguments of the Pelts, terminated at 5 o'clock. But again, we don't agree with that. if you look at the text message, the final text message on December the 30th that Mr. Benjamin sent to the real estate agent, they're waiting on a signed agreement. They're not waiting on just, hey, we've got a text message and a disputed phone call. We're waiting on a signed agreement. We're waiting on your pre-approval letter and the addendum. Now, again, in this verbal, whatever it was that goes into addendum, we never did receive the addendum. Now, the issue of estoppel, are we stopped from raising the statute of frauds? One, no, because what I said just a second ago. But the other part of that is, after these text messages, the agent and Mr. Pelt testified that they discussed what did they mean by they're going to continue to sell. Mr. Pelt understood that the Benjamins had a right to sell the property after, because there was no written contract, and the contract itself has provisions in that. If you don't execute it, you don't bind it, you're not bound, you could sell it to someone else. The other part, and even more interesting, is the agent told Mr. Pelt and testified that they can show it to somebody else in case that you don't qualify and you back out or you change your mind again. So we don't have a contract. These documents that they say, and I understand the statute of frauds can be, I guess, trumped by documentation, but in this case, we don't have any documentation. The contract on its terms expired. The only documentation that you've got in effect is 2 text messages, one on Saturday that says, I got to talk to my wife and I'll get back with you tomorrow. On the next day, the only text message you've got is the fact that we're waiting on a written agreement and the addendum and a pre-approval letter. It's just a contract.
Let me ask you a question before all your time's up.
Yes, sir.
Ms. Connell raised the question on your cross appeal about the fact that your slander of title claim was not appealed. Do you agree with that?
No, I appealed the damages claim, Your Honor, in regards to 66-21-108, and we addressed those issues. And so we assert that the right that was accrued, which would have been when they filed that lienless pendants, anchored that right under that damage statute.
All right, sir. Thank you.
Yes, sir. Do the court, any other questions or issues?
Don't see any.
Your Honor, that's all I have. I appreciate the opportunity to do this, and thank you.
Thank you. Thank you both. Ms. Lindsay, would you please recess the court? Would you do it without being silenced? Okay, the court's in recess.
The Honorable Court of Appeals is now in recess.
Thank you, Ms. Lindsay.
Thank you, Your Honor.
The attorney